Our Scottish civil court system is hierarchical. At the very foot we have the sheriff courts, which are broadly comparable to the county courts in England. There are currently 39 sheriff courts in Scotland, and those are split into 6 different court areas for administrative purposes, which are known as sheriffdoms. Civil cases in the sheriff court are heard by a sheriff sitting alone.
Originally, sheriffs were appointed by the monarchy as the local representative of the king or queen overseeing judicial and administrative matters in their area on his or her behalf. It later evolved into a professional appointment. To be appointed a sheriff, you must have been qualified as a solicitor or an advocate in Scotland for at least 10 years. You are then appointed by the Queen on the recommendation of the First Minister.
Disputes worth any sum of money can be raised in the sheriff court. There's no minimum or maximum amount. A new court, called the All Scotland Sheriff Personal Injury Court, was introduced in January 2016, and it deals with personal injury cases only. It's located within Edinburgh Sheriff Court.
All Scottish solicitors have a right of audience in the sheriff courts, although advocates, which is the Scottish equivalent of a barrister in England and Wales, are frequently instructed in more tricky cases. Appeals may be made from the sheriff court to the Sheriff Appeals Court.
Next up in the hierarchy is the Court of Session, which is Scotland's supreme civil court. The Court of Session is located at Parliament House on Edinburgh's Royal Mile. The building itself is absolutely steeped in history. As the name Parliament House implies, it once housed the Scottish Parliament. This was the pre-Union 1707 Parliament of Scotland, which sat in its magnificent Parliament Hall. The hall is still busy during court days now, with solicitors meeting their clients and their advocates, and advocates are traditionally seen pacing up and down the hall discussing their cases. They pace because the conversation's less likely to be overheard because of the acoustics in the hall. The Court of Session is a court of first instance as well as being a court of appeal. Because of this dual function, it's therefore comparable to the High Court and the Court of Appeal in England. It does not, however, have jurisdiction over disputes of a value less than £100,000, and these lower value disputes must be raised in the Sheriff Court.
The Court of Session is divided into the Outer House and the Inner House. The Outer House consists of judges known as Lords Ordinary, who hear cases sitting alone or on certain cases with a civil jury. However, civil jury trials are relatively uncommon in Scotland these days. Designated judges deal with certain specialist matters, and there are special procedures for intellectual property disputes, commercial cases, personal injury cases and family law matters. The Inner House is in essence the appeal court, although it has a small range of first instance business as well. It's divided into the first and second divisions of equal authority and presided over by the Lord President in the First Division and the Lord Justice Clerk in the Second Division. Each division is made up of 6 judges, but the quorum is 3. Sometimes, due to the pressure of business, an extra division of 3 judges sits. The divisions hear cases on appeal from the Outer House and from the Sheriff Appeals Court, and they also hear appeals from certain tribunals and other bodies. If it is necessary to overrule a previous binding authority, a larger court of 5 or more judges may be convened.
At the top of the hierarchy is the Supreme Court, which is the final court of appeal for the UK for civil cases. The right of appeal to the Supreme Court is not automatic. You require either permission from the Inner House of the Court of Session or from the Supreme Court itself in order to bring an appeal. There are currently 2 Scottish Justices of the Supreme Court, and it's been a long-standing convention that there should always be at least 2 Scottish judges in the Supreme Court.